Listen to me very carefully. I'm not saying that for drama, and I'm not saying it to scare you for clicks. I'm saying it because one quiet, well-intentioned decision you might be planning right now can cost your children $200,000. Real money, their money, gone. And the worst part, you'll think you were being generous when you did it. I've spent over 4 decades building wealth, protecting wealth, and watching families either pass it on intelligently or light it on fire with a smile on their face. I've sat across the table from parents who did everything right in life, worked hard, paid off their home, raised their kids, and then made one small, helpful move at the end that absolutely destroyed the outcome. No fraud, no scams. Just ignorance mixed with good intentions, a very expensive combination. And let me be clear about something. This isn't theory. This isn't a textbook example or a clever tax trick floating around the internet. These are real families, real houses, real tax bills, and real regret. I've seen the phone calls after the damage was done. I've seen adult children stare at 6-figure tax bills they never should have owed. And I've seen parents realize too late that trying to be nice ended up being cruel. People love to believe that estate planning is complicated, mysterious, or only for the ultra-wealthy. That's nonsense. The truth is much simpler and much more uncomfortable. The most common estate planning mistake in America isn't complex. It's obvious. It's popular. And it's made every single day by people who think they're being smart. This is the kind of mistake that doesn't explode immediately. It waits. It smiles politely. And then, years later, when you're gone and can't fix it, it hands your kids a bill the size of a small house. So if you're tempted to tune this out, don't. This is one of those moments where paying attention for a few minutes can protect everything you spent a lifetime building. Let me paint a picture that will feel uncomfortably familiar to most of you. You bought your house a long time ago. Maybe the late 80s, maybe the 90s, back when interest rates were high, kitchens were ugly, and nobody thought a starter home would someday be worth a fortune. You paid $80,000, maybe $100,000. At the time, it felt enormous. You scraped together the down payment, signed papers that made your hands sweat, and told yourself you'd figure it out. And you did. You raised your kids there. You replaced the roof. You remodeled the kitchen when avocado green finally went out of style. You fixed the leaky faucet yourself because calling a plumber felt irresponsible. Decades passed, and quietly, without you really noticing, that house stopped being just a place to live. It became the biggest asset you will ever own. Today, that same house is worth $600,000. 700, maybe more. In many cases, it represents 50, 60, even 70% of everything you've built in your entire life. Not your stocks, not your savings. That house, the walls, the driveway, the living room where your kids did homework and rolled their eyes at you, and now you're thinking about the future. You're thinking, I don't want this to be complicated for my kids. You want to be helpful. You want to be fair. You want to make things simple. That's the word everyone uses. Simple. Just put their names on it. Just handle it now. Just avoid paperwork, lawyers, courts, and headaches later. After all, you worked for it. You paid for it. It's your house. Why should it be hard to give it to your children? That instinct is human. It's loving. It's logical. And it's exactly where people go wrong. Because in finance, and especially in estate planning, the thing that feels simplest is very often the most destructive. The tax code doesn't care that you're being generous. The IRS doesn't reward good intentions, and the law has a nasty habit of punishing shortcuts. I've seen this play out countless times. Parents sitting comfortably confident they've handled everything only to leave behind a mess they never imagined. They weren't careless. They weren't greedy. They were just trying to make life easier for their kids, and they trusted common sense instead of understanding how the system actually works. So when I say this applies to you, I'm not guessing. If you own a home, if you've held it for decades, if you want to pass it on without drama, you're already standing in the danger zone, and the trap doesn't look like a trap at all. It looks like kindness. It looks like simplicity. And that's exactly why it's so dangerous. Now, let's talk about the mistake itself. The one I see more than any other, the one people defend passionately right up until the moment it destroys them. Adding your children's names to the deed of your house while you're still alive. That's it. That's the move. And if you've already done it, I need you to keep listening and not panic yet. Here's why people love this idea. It feels clever. You think you've found a shortcut. You avoid probate. You avoid lawyers. You avoid paperwork. You avoid the court system. You tell yourself, when I'm gone, the house just passes to them automatically. Clean, easy, no drama. People say this to me with a little smile, like they've outsmarted the system. I don't blame them. On the surface, it sounds smart. It sounds efficient. It sounds like something a responsible parent would do. But this is where intuition betrays you. When you add your kids to the deed while you're alive, you are not doing some magical transfer. You are making a gift. And the tax system treats gifts very differently than inheritances. This is where the trouble starts, and it starts quietly. Let me explain this in plain English the way I would explain it to someone sitting across the table from me. Every property has something called a cost basis. That's just a fancy way of saying what you actually paid for it, plus the money you put into improving it over the years. Not what Zillow says it's worth. Not what your neighbor sold theirs for. What you paid. So let's use a very normal example. You bought your house in 1980 for $100,000. Over the years, you renovated the kitchen. You added a bathroom. You replaced the roof. You finished the basement. Let's say you put $90,000 into improvements. That means your total cost basis is $190,000. That's your number. Fast forward 40 years. The house is now worth $750,000. Congratulations. You did well. That's real wealth. Now, here's where people make the fatal mistake. They add their kids to the deed while they're alive. When they do that, their kids don't get the current value as their starting point. They inherit the old cost basis. Your cost basis. The one from decades ago. So when you eventually pass away and your kids decide to sell the house, maybe they don't live nearby, maybe they need the money, maybe they just don't want to live there. They sell it for $750,000. And now the taxman shows up, not because anyone did anything illegal, not because anyone was greedy, simply because the math says so. $750,000 minus $190,000 equals $560,000 in capital gains. That's the taxable amount. At current federal rates, that's easily $80,000 to $100,000 gone. And if you live in a state with income tax congratulations, you've just added another painful layer. In some places, that total tax bill creeps dangerously close to $200,000. Let me say that again slowly. By trying to be helpful, by trying to keep things simple, you may have handed your children a tax bill larger than the price you originally paid for the house. That's not smart planning. That's financial self-sabotage with good intentions. And the tragedy is this: most people don't find out until it's irreversible. There's no rewind button, no apology to the IRS, no explanation that starts with, "I didn't know." The system doesn't care. The check is due. This is why I call this the most dangerous estate planning mistake in America. Not because people are reckless, but because they're confident. confident they've solved a problem that didn't need solving, confident they've made life easier, and confident right up until the moment their kids realize how expensive that confidence turned out to be. Most people stop thinking once they hear the tax number. They say, "Okay, that's bad," and then they mentally file it away as a future problem. But taxes are only the opening act. They're the smallest, cleanest part of this disaster. The real damage comes later, and it doesn't show up on a spreadsheet. Let me ask you a few uncomfortable questions. What if your child gets sued? Not because they're reckless, just because life happens. A car accident, a business deal that goes sideways, a lawsuit that has nothing to do with you. The moment your child's name is on that deed, your house is no longer just your house. It's now part of their financial life, and that means it's exposed. A judgment against them can suddenly put a target on the home you spent decades paying off. That safe asset you thought you were protecting is now fair game. What if your child gets divorced? I know nobody likes to think about that. Everyone believes their kid's marriage is different. The statistics don't care. In many states, property owned during a marriage becomes part of the marital estate, which means the house you worked 30 or 40 years to own can end up sliced in half and handed to an ex-spouse you barely tolerate at Thanksgiving. Romance aside, that's a brutal way to lose control of your legacy. What if your child runs into financial trouble? Bankruptcy, bad business decisions, creditors knocking on the door. Suddenly your home is sitting in the middle of their storm. You didn't just help your child, you tied your biggest asset to every mistake they might make for the rest of their life. That's not generosity, that's exposure. Now let's talk about control, because this is where things get truly uncomfortable. Once your child's name is on that deed, you don't get to just change your mind. You can't wake up one morning and decide to undo it. You need their permission. And if you think that will always be smooth and reasonable, I admire your optimism. What if you need to sell the house to pay for long-term care? Nursing homes are not cheap. $8,000 a month. $10,000. $12,000. What if you need that money and your child says no, or one child says yes and the other says no? Congratulations, you've just turned your retirement into a negotiation. I've seen parents stuck in houses they can't sell watching their savings drain away because they gave up control too early. I've seen siblings turn into enemies over whether to keep or sell the property. I've seen spouses whisper in ears. I've seen family dinners end in silence and resentment, all because someone thought years earlier that putting a name on a deed was a harmless shortcut. And here's the cruel irony. This mistake is usually made by people trying to be fair, trying to avoid conflict, trying to do the right thing. Instead, they plant the seeds for the very fights they hope to prevent. So ask yourself this. What if everything doesn't go perfectly? What if life does what it always does and throws a few sharp turns your way? Because once you give up control of that house, you don't just give up a legal right. You give up leverage, you give up flexibility, and you put yourself in a position where the final years of your life depend on decisions you no longer get to make. That's when people realize this was never just about money. It was about power, and they handed it away without even realizing it. Now take a breath, because this is the moment where the lights come back on. Up to now, I've shown you the cliff. I've shown you how easy it is to fall off it. But here's the good news. The system, for once, actually gives you a gift. And all you have to do to receive it is not mess it up. There is a simple concept at the center of this entire mess, and once you understand it, everything clicks. It's called the step-up in basis. Don't let the name scare you. This is not complicated. In fact, it's one of the most generous things the tax code does for ordinary families. Here's how it works in real life. If you die owning your home either directly or through the right structure, the value of that house is reset on the day you die. Reset. Clean slate. The IRS looks at the fair market value on that day and says, that's the new starting point. Not what you paid in 1980, not what you spent on renovations. The value on the day you're gone. So let's replay the same example, but this time the smart way. You bought the house for $100,000. You put in $90,000 over the years. Your old basis is $190,000. Today, the house is worth $750,000. Instead of gifting it while you're alive, you simply hold on to it. You live in it. You control it. You own it. Then one day, many years from now, your kids inherit it. On that day, the basis becomes $750,000. If your kids sell it the next day for $750,000, they owe zero capital gains tax. Zero. Not a penny. Even if they sell it later for a bit more, they only pay tax on the small increase after your death, not the entire 40-year gain. That's the difference between writing a 5-figure check and writing a 6-figure check. That's real money staying in your family. So now the obvious question comes up. Kevin, that sounds great, but what about probate? I hear this all the time. People are terrified of probate. They've heard stories, long delays, big fees, lawyers circling like vultures. And yes, probate can be annoying. In some states, it's worse than others. But here's the part nobody likes to say out loud. Even bad probate is cheap compared to blowing the step up in basis, but you don't even have to choose. This is where smart planning comes in. There is a way to avoid probate and keep the step up. And it's not exotic, it's not shady, it's not a loophole. It's called a revocable living trust. This is what people with actual money do, not because they're sneaky, but because they understand incentives. A revocable living trust lets you put your house into a legal container that you still control. You're the trustee. You live in the house. You can sell it. You can refinance it. You can change your mind. Nothing changes in your daily life. But when you die, the trust takes over. The house doesn't go through probate. It passes directly to your kids according to your instructions, quietly, privately, cleanly. And because the trust is revocable and still considered yours while you're alive, the IRS treats the house as part of your estate. That means your kids still get the step up in basis. You get the best of both worlds. Now let's talk about cost, because this is where people hesitate. Setting up a proper revocable living trust usually costs somewhere between $1,500 and $3,000. That's it. And I know nobody likes writing that check. But let's put this in perspective. You're spending about $2,000 to protect $100,000 to $200,000 of your family's money. Show me another investment that does that with zero market risk. There isn't one. This is not speculation. This is not timing. This is math. Clean, boring, beautiful math. What I love about this solution is that it's not clever. It's not aggressive. It doesn't try to outsmart the system. It works with the rules exactly as they're written. The tax code says, if you die owning the asset, we give your heirs a reset. All a revocable living trust does is make sure you still own the asset at the right moment without dragging your family through court. This is why I keep saying the same thing over and over. In estate planning, the most dangerous move is trying to be clever. The smartest move is often doing nothing. Until you do the one thing that actually matters. Hold the asset. Keep control. Let the step-up happen. And if you want efficiency and privacy, put the house in a trust. That's the light in the room. That's the exit sign. And once you see it, the idea of giving away your house early suddenly looks as ridiculous as it really is. Now let me bring this home because understanding this means nothing if you don't act on it. And I don't mean panic. I don't mean calling your kids tonight and apologizing for something you haven't done yet. I mean taking calm, deliberate steps, like an adult who understands what's at stake. First, and I'm saying this as clearly as I possibly can, do not add your children's names to the deed while you're alive. If you've already done it, don't beat yourself up, but don't ignore it either. Talk to a qualified estate planning attorney and ask how to fix it. The sooner the better. Second, find the right professional. Not your divorce lawyer, not your cousin's buddy who dabbles in law. An estate planning attorney who does trusts every single day. This is not the place to bargain hunt. Third, set up a revocable living trust and actually put the house into it. Having the paperwork sitting in a drawer doesn't protect anything. The asset has to be properly transferred. This is where people mess up by stopping halfway and telling themselves they're done. Fourth, review it periodically. Life changes, laws change, families change. A trust is not a tattoo. You can and should adjust it as your situation evolves. And here's the part people don't like to hear. Every month you delay is a month you're exposed. People don't plan to die on inconvenient timelines, but they do it anyway. Procrastination is not neutral. It's a risk. You spent decades building this. Early mornings, late nights, sacrifices nobody applauded. Don't let one lazy decision at the finish line undo all of it. Protect the house. Protect your family. And don't confuse doing nothing with doing the right thing. Sometimes the most loving move is simply not making a mistake.